Evolution of Global Justice. This presentation explores the transformation of international criminal justice from the early ad hoc tribunals to the establishment of the permanent International Criminal Court and the growing role of national courts in addressing human rights crimes. The international community has demonstrated a growing commitment to accountability, justice, and the rule of law. This presentation will examine this evolution, highlighting key milestones, challenges, and the path forward for global justice. The modern history of prosecuting human rights crimes began after World War II with the Nuremberg and Tokyo Tribunals. These ad hoc tribunals were groundbreaking, establishing the principle that individuals, including the heads of state, could be held accountable for violations of international law. However, they were criticized as victor's justice and lacked a framework for addressing future atrocities. Despite their limitations, they laid the foundation for international criminal law. In the 1990s, the international community turned to ad hoc tribunals once again, this time to address atrocities in the former Yugoslavia and Rwanda. The International Criminal Tribunal for the former Yugoslavia, ICTY, and the International Criminal Tribunal for Rwanda, ICTR, were more inclusive and impartial than their predecessors. However, their temporary nature highlighted the need for a permanent universal mechanism to address human rights crimes. ICC's origins trace back to the early 20th century, with proposals for an international court emerging after World War II. However, it was not until the 1990s, following the establishment of the ICTY and the ICTR, that the idea gained serious traction. The idea of a permanent international criminal court gained momentum after the Cold War. The Rome Statute, adopted on July 17, 1998, was the culmination of decades of advocacy and negotiation, establishing the International Criminal Court, ICC. The ICC became operational on July 1, 2002, marking a major step forward in the fight against impunity. It was designed to complement national judicial systems, stepping in only when states are unwilling or unable to prosecute serious international crimes. The ICC is headquartered in Hague, Netherlands, and has 123 member states as of 2023. However, major powers like the United States, China, Russia, and India are not members, citing concerns over sovereignty. The court's jurisdiction covers genocide, crimes against humanity, war crimes, and the crime of aggression, but only when national courts are unable or unwilling to act. The ICC's process involves several stages. The first one being preliminary examination, then investigations, then they issue charges and arrest warrants, then trial, and then appeals, and then sentencing and reparations. And what you'll notice about all of these is they're very professional and official proceedings of the court. This stands as a beacon of justice characterized by its highly professional and official proceedings. This modern institution epitomizes fairness and thoroughness in its judicial process, a stark contrast to the chaotic and arbitrary nature of the kangaroo courts that prevailed in medieval Europe. In those times, trials were often a mockery of justice, lacking in due process and impartiality. The ICC, on the other hand, is dedicated to upholding the rule of law and ensuring that justice is served with integrity and transparency. Lack of state cooperation and accusations of bias. Its focus on African cases has led to criticism of selective justice, though it has also opened investigations in Asia and Latin America. The ICC also doesn't have the ability to enforce its rulings, which leads to its dependency heavily on other countries to enforce its rulings. Despite these challenges, the ICC remains a cornerstone of the international justice system. In addition to international tribunals, national courts have increasingly played a critical role in prosecuting human rights crimes through the principle of universal jurisdiction. This allows states to prosecute individuals for serious crimes regardless of where they were committed. Landmark cases such as the Pinochet and Eichmann trials have demonstrated the potential of national courts to address international crimes. Countries like Belgium, Spain, Germany, and Argentina have been at the forefront of using universal jurisdiction. For example, in 2021, a German court convicted a former Syrian intelligence officer for crimes against humanity. These cases highlighted the growing role of national courts in complementing international justice mechanisms, like the ICC. However, universal jurisdiction in courts doesn't come without its challenges. Despite its potential, it faces issues such as political interference, selectivity bias, and legal complexities. Critics argue that it is often applied unevenly, targeting individuals from weaker states while ignoring crimes by powerful nations. Nonetheless, it remains a vital tool in the fight against impunity, emphasizing the importance of global accountability and justice. The evolution of international justice reflects a shared aspiration for a world where accountability prevails over impunity. From the Nuremberg trials to the ICC and the growing role of national courts, the fight for a global justice continues. As we move forward, cooperation and commitment will be essential to ensuring that no crime goes unpunished, no matter where it occurs. Understanding the transition from tribunals to international courts will help you understand our next presentation on human rights, the transition from declarations to treaties.